Welcome, everyone. The Historical Society of the D.C. Circuit and the Federal Communications Bar Association are pleased to present to you today our program on FCC indecency cases in the D.C. Circuit, an historical perspective. I want to introduce Mark Schneider, the president of the Federal Communications Bar Association, who will at least come forward and wave at you.
And not too much more than that, except to thank the D.C. the Historical Society and Chris Wright, who helped put together this panel. And welcome.
I want to introduce to you Christopher J. Wright, who, as Mark said, conceived and put together today's panel discussion and will serve as our moderator. Chris is well positioned to do so. He served as Deputy General Counsel and then General Counsel of the FCC in the period 1994 to 2001, and he argued the 1995 Action for Children's Television case in behalf of the FCC. In that case, the D.C. Circuit sitting en banc upheld the Commission's ban on indecent broadcasts between the hours of 6 a.m. and 10 p.m. Chris will introduce the panelists to you. Chris.
Thank you. Now people know who I am. Thanks. Supreme Court will hear oral argument 3 weeks from today in FCC v. Fox Broadcasting, which, as I'm sure many of you know, grows out of the FCC's recent decision prohibiting the broadcast of fleeting expletives, such as Cher's use of the F word while receiving a Golden Globe Award. More than 20 briefs have been filed in that case, but I submit that if you want to get well-versed in the really important issues, no offense to those of you I see who filed amicus briefs in that case, you'd be well advised to read the D.C. Circuit's opinions in FCC indecency cases. In the 1977 Pacifica v. FCC case, which grew out of George Carlin's famous 7 dirty words monologue, Judge Tam wrote the opinion for the court, Judge Bazelon wrote a concurring opinion, and Judge Leventhal wrote a dissenting opinion. In the 1995 en banc case that Steve mentioned, Judge Buckley wrote the opinion for the court. Judge Edwards and Judge Wald wrote dissenting opinions. Not surprisingly, Judge Tam, Bazelon, Leventhal, Buckley, Edwards, and Wald addressed the hard issues presented by those cases in a thorough, scholarly, yet sometimes quite passionate fashion that warrants continued attention. We have an excellent panel to discuss the D.C. Circuit's indecency cases. Professor Glenn Robinson has been on the faculty of the University of Virginia Law School for more than 30 years. From 1974 to 1976, he was an FCC commissioner, and of particular relevance today, issued a scholarly concurring statement in the FCC's Pacifica case. Judge Timothy Dyke has served on the Federal Circuit since 2000. Before he took the bench, Judge Dyke was a leading appellate lawyer who had clerked for Chief Justice Earl Warren and for Justices Stanley Reed and Harold Burton. Of particular relevance today, Judge Dyke represented broadcasters in all or nearly all of the FCC indecency cases that found their way to the court in the 20 or 25 years before he took the bench. Judge Patricia Wald served on the D.C. Circuit from 1979 to 1999 and needs no introduction to this group. But you might not know that since retiring, Judge Wald was the United States representative to the International Criminal Tribunal for the former Yugoslavia and then a member of the Iraq Intelligence Commission. As I mentioned previously, Judge Wald wrote a dissenting opinion when the en banc court upheld the 6 a.m. to 10 p.m. ban on indecent broadcasts. There are a number of people in the audience today who are experts on indecency law, and I hope those experts will bear with me for a few moments while I try to get the rest of us on the same page with a 2-minute overview of FCC indecency law. Perhaps surprisingly, the key statute is a criminal statute, 18 U.S.C. 1464, that prohibits the utterance of, quote, any obscene, indecent, or profane language, unquote, on radio or broadcast television. But criminal prosecutions are either rare or non-existent. Instead, the statute is enforced by the FCC, which typically issues a fine or a warning. A repeat offender or a broadcaster that egregiously violates the provision is in danger of losing its broadcast license, however. The FCC doesn't monitor broadcasts. It only responds to complaints. It appears clear that advocacy groups are increasingly filing complaints. Although the statute refers to, quote, obscene, indecent, or profane, unquote, language, the vast majority of cases have focused on the meaning of indecency. The FCC defines indecency as, quote, language or material that, in context, depicts or describes in terms patently offensive as measured by contemporary community standards for the broadcast medium, sexual or excretory activities or organs, unquote. I know we have some law students here. There will be a test on this later. The FCC does not look to local community standards or the sensibilities of complainants to decide whether broadcast is indecent, but instead looks to the standards of a hypothetical American broadcast viewer or listener. I'm sure everyone is aware of a case that resulted from Supreme Court, the Super Bowl halftime broadcast, where Janet Jackson bared her breast for a brief moment. Nevertheless, the vast majority of cases considered by the FCC and the courts have involved allegedly indecent language, particularly on the radio rather than nudity on television. Finally, in 2001, the FCC issued a document that provides examples of broadcasts that the FCC has found to be indecent or not indecent, and listed 3 factors as being significant to its determinations. The first factor was whether the broadcast was explicit, and a number of Howard Stern broadcasts were provided as examples of explicit references to sexual or excretory material. The second factor is whether the material dwelled on the sexual or excretory material or just made a fleeting reference to it. George Carlin's 7 Dirty Words monologue is an example of a broadcast that dwelled on indecent language, and in the case currently before the Supreme Court, the FCC changed its approach and decided that it would prohibit fleeting expletives henceforth. The third factor is whether the material was presented in a titillating manner. An example found to be indecent under this standard involved a broadcast quoting Jessica Hahn's description of her affair with Jim Baker, where one DJ emphasized the salacious aspects of the affair while the other DJ made sheep noises in the background. A counterexample involved the Branton case, in which the FCC held that an NPR broadcast of John Gotti using some form of the F word 10 times in 7 sentences was not indecent because, like most NPR broadcasts, it was not titillating. With that background, let's turn to the panel. Starting with Pacifica and then moving to the later decisions, we intend to save 15 minutes for questions from the audience, so please make mental notes of issues you'd like to see addressed further or issues you'd like to see addressed that weren't. Professor Robinson, I know that you recently filed an amicus brief in the Fox case on the side of the broadcasters, but in 1975 you concurred in the FCC's Pacifica decision that concluded that George Carlin's 7 Dirty Words monologue was unfit for broadcast at 2 p.m. in the afternoon. Would you take us back to 1975 and describe how you analyzed the case?
Yeah, sure, as best as I can remember after 33 years. You lose a few of the details along the way. Also, my memory is probably colored by my change of views. Things no longer seem to me now as they seem to have seemed to me then. Pacifica came along at the tail end of an episode that was called at the time Topless Radio, variety speak label for what were basically smarmy talk shows. One of the most famous of these was Sonderling Broadcasting, which was decided, I think as I recall, 1974. Went up to the Court of Appeals, was affirmed under the name of Illinois Broadcasting. Topless Radio was handled as obscenity at that time. It was probably borderline, but we got an affirmance from the Court of Appeals at the time. It was decided before I got there, that these talk shows were indeed obscene. In this particular Sonderling case, it was all about callers calling in with their sexual hang-ups, etc., and a long kind of dialogue that we now associate with Howard Stern. But that, I think, had pretty much died down when along comes Carlin's famous monologue, for which he's earned immortality, I must say. It was pretty clear, at least it was pretty clear to the lawyers on the commission. There were only 3 of the 7 members then were lawyers, but I think the others had good legal advice. It was clear that this couldn't qualify as obscene. Whatever else you think about George Carlin, his monologue does not appeal to the prurient interest. Whether it would have redeeming social value or not, well, people can differ on that. It was quite genuinely funny, I think. Even several of us on the commission thought so. But that left us in a bit of a quandary, because if it wasn't obscene, what was the precedent for regulating it? The statute, of course, reads, as Chris mentioned, obscene, indecent, and profane. We didn't give any consideration to the word profane, although the FCC has recently discovered it in the statute. But we did seize on the word indecency. So was Carlin's monologue, the 7 filthy words you can never say on the public's airwaves, quote unquote, indecent? Well, the only precedent we had to act on at the time was a case decided in 1970 called Eastern Educational Radio, involved an interview with Jerry Garcia, and was full of a lot of the F words and S words that were replete throughout the interview. The FCC decided at that time that it couldn't obviously be couldn't be treated as obscene either. So they focused on the word indecency, but there was no real precedent for picking out the word indecency. There's just no jurisprudence on it. What the FCC said, however, was, well, we're going to take the indecency and say that indecency is more or less obscenity without the prurience. Okay? So that was the precedent we had in the Pacifica case. The problem with that precedent is, after Eastern Educational Radio, the Supreme Court changed its definition of obscenity, number 1, in the Miller case, and 2, in another case at the time by the memorable name of 12 200-foot reels. You can get the rest just by imagining it. The court, in a dictum, said that we don't recognize indecency as having any meaning other than obscenity. Were we to do so, there might be some constitutional problems of vagueness, etc. So in a dictum, what we had to face then was the fact that indecency didn't seem to have any constitutional stature. We managed to slide around that by saying, well, but that was in a different statute. Now, the words were the same as in 1464, but the statute in this particular Supreme Court decision dealt with interstate transmission, transportation, not broadcasting. So, well, everybody knows broadcasting is different, so we said, we'll treat this as a special case. And I must say, I thought at the time that was, I've never thought broadcasting was all that different, so it's a little bit out of sorts with that idea. What sold me on it, however, was that the FCC came up with a different kind of regulatory take on the problem. And instead of saying, well, we're going to suppress it the same as obscenity, we're going to simply regulate it the way we regulate time, place, and manner cases. And in particular, we're going to regulate the time. So we're going to treat this like it was a nuisance. And the appeal here then is to sort of moving this stuff into the late hours when children are not likely to be in the audience. I can say something more about the children, role of the children here, but that becomes a very prominent feature of the whole jurisprudence that follows. That idea appealed to me a little bit, at least in retrospect. It seemed to me to make a certain amount of sense, because it was a way of compromising between a kind of a zero tolerance, total suppression on the one hand, versus a laissez-faire solution on the other. And I don't think anybody at the FCC, I certainly, myself, I didn't think that this was going to be the beginning of a struggle against indecency. It was one case that popped out of the end of this sequence of topless radio cases, and I think we believed that one decision pretty much take care of it. Bear in mind that this phenomenon at that time was identified only with radio, and by and large the cases all involved either campus radios run by students or subscriber-supported, listener-supported radio, like Sonderling was, like Pacifica. So, and they didn't go through unlike television in that time, television broadcasting, there was no network censor at work here. So we had every reason to think that the problem would stay confined to a handful of maverick broadcasters. So I don't know that we did any deep analysis of the problem or where it was going to go thereafter. We cobbled together an opinion which has at least the saving grace of being only 4 pages long, which is almost record-setting for the FCC. You have to love those days when you could read a whole opinion in 4 pages. I added a couple more pages of concurrence, a sort of pedantic spin on the problem. But it was short and fairly simple. And the basic idea was we're going to treat this as a nuisance problem. We will confine this to hours a day, unspecified. We will deal with the 7 filthy words. They didn't confine it to that. The FCC later did, in fact, confine it for a time to those precise words. We didn't at that time. But that was the gravamen. It was extremely offensive words uttered on broadcasting when children might likely to be in the audience. And basically the rest is history, as they say. Went up to the Court of Appeals. The Court of Appeals reversed, and the Supreme Court reversed the reversal. I must say, somewhat to my surprise, I was not then on the commission, but I was a little surprised by the Supreme Court's decision. I wasn't necessarily disapproving at that time. I hadn't then acquired the wisdom that I have since.
Well, Judge Dyke worked on the case when it got to the Supreme Court, and of course, as you just say, that reversed. It was a very divided court that reversed a divided D.C. circuit. And can you tell us about those decisions, Judge Dyke?
Thank you, Chris. I guess I have to start out with a disclaimer and say that I'm here speaking as my former self rather than my present self. So please attribute everything I say to my private practice experience. I guess in revisiting Pacifica, one of the things that's most startling to me, and I haven't gone back to look at the briefs, so what I'm assuming may not be correct, but one of the most startling things to me is the assumption, the running assumption, that if you were going to have indecency regulation, that the FCC was the appropriate authority to do it. And the notion that you could impose punishment for obscenity without a jury trial probably raises significant First Amendment problems. But my recollection is that at the time of Pacifica, people were not worried that this was being done by an administrative agency rather than a jury trial. And there was an opening to argue that Congress contemplated a jury trial because, of course, as you mentioned earlier, Section 1464, the indecency prohibition, is a criminal statute. And one of the concerns, looking back at the English experience which led to the First Amendment, was the idea of having an administrative agency involved in censorship issues. That's also reflected in Section 326 of the Communications Act, denying the Commission the authority to censor. And a lot of people think that there are pretty good reasons for not having administrative agencies regulating the content of speech. After all, an administrative agency, unlike a jury, isn't necessarily familiar with contemporary community standards. And there is the risk that the administrative agency will be influenced by political considerations, and that it will do the kinds of things which historically have been of concern. But I don't recall at the time any argument that the FCC shouldn't be doing this, that it should be, if it was going to be done at all, that it should be done by a jury trial and a criminal charge. Everyone, my recollection is, just assumed that it was appropriate for the FCC to engage in content regulation, and if there was going to be indecency regulation, it seemed appropriate to have the FCC do that. And you have to view this against the historical situation at the time of the Pacifica case. Of course, to focus on the D.C. Circuit and indecency regulation is, in a way, taking things a bit out of context, because the D.C. Circuit was concerned at the time with a whole host of FCC programming regulation in the license context, suggesting that licenses needed to be taken away from broadcasters for not having the right kind of programming, even though the FCC didn't seem to want to do that, to the regulation of political programming, you know, 315, a lot of 315 cases, equal time cases, cases like primetime access, though eventually that went to the Second Circuit. But there was a whole host of program-related issues, metro broadcasting, that came through the D.C. Circuit in the period from the late 1960s, beginning with the Red Lion decision itself, and coming up for the next several decades. So I think the indecency issues have to be considered in that overall context, that the FCC was seen as having some role in the regulation of programming. I remember as a young associate going to the firm and being confronted first with this financial interest proceeding in which there was a gentleman at the FCC named Ashbrook Bryant, and who had come up with this report beating on the networks for being an oligopoly. And of course it was a favorite sport with the FCC in those days to beat on the networks, to beat on broadcasters. Newton Minow gave the famous vast wasteland speech. So broadcasters were not very popular, and it was viewed that government had a role to play in improving the programming of broadcasters generally. It wasn't just in the area of indecency. So you have to see it in that context. Now, indecency was a particular problem, it seemed to me, because a lot of people didn't see very much value in indecent speech, and you certainly see that in reading the Pacifica opinion, even though the concurrence by Justice Powell and Justice Blackmun says, well, no, we're not concerned with the value of indecent speech. I think one has a hard time reading either the majority of the concurrence without concluding that the Supreme Court justices felt that indecent speech really didn't have any particular value, so they weren't going to worry too much about the First Amendment in this context. And it's a little ironic that the case involved the Carlin monologue, because if you go read the Carlin monologue, Glenn was saying that he wasn't sure that the Carlin monologue had social value. I mean, it is, after all, a criticism of the FCC. It's making fun of the FCC. It is a political piece of theater. So perhaps unlike Janet Jackson and some of these other things, the case that came up to the Supreme Court involving indecency didn't involve things that people would look at and say, well, we don't understand the value of this. The Carlin monologue was political speech. It wasn't just entertainment, and yet that seemed to get passed over without a great deal of thought. Now, the other thing about Pacifica is I think you're left a bit wondering what it is that makes broadcasting special. And, you know, the Pacifica decision does not rely on the spectrum scarcity rationale, whatever that rationale might be from the Red Lion case, but talked about the protection of children and intrusion into the home. And the question is, of course, well, people don't have to buy radio and television sets. They could not tune them in the first place. And that's a sort of unstated assumption, it seems to me, of the decision, is that people have a right to have radio and television in the home and to have it fit for their children, an assumption which is not made with respect to cable and direct satellite programming. So there's it seems to me there's some unexamined premises. Are we going to hear more about that in the Fox case? Perhaps, perhaps not. But the whole treatment of broadcasting as being different is something that really didn't get in-depth treatment in the Pacifica case, and you're left a little bit unsatisfied. I suppose at the end of the day, maybe the best argument for regulation in this area would be that the broadcasters were using a public facility, and that somehow the government had an interest in making the programming that came over that public facility accessible to the entire audience, at least for a significant part of the broadcast day. But that, while that may be an unstated assumption in Pacifica, it's not there in the opinion, and that theory is not necessarily consistent with the various Supreme Court decisions dealing with other public facilities, such as auditoriums. Pacifica is a wonderful case because you can spend a lot of time analyzing it and thinking about it and trying to figure out what was meant. There is certainly, it seems to me, almost a feeling of anger comes through in some of the discussion, the pig in the parlor metaphor, for example. Not a lot of sympathy with the idea that there might be value in broadcasting this kind of material, and certainly as well a feeling that because the Carlin monologue was transcribed, and I think this is another significant aspect of the Pacific case, because it was transcribed, it was available to people who could buy it on a record. So the justices, it seemed to me, didn't look at the decision as preventing access to the Carlin monologue even in the primetime viewing hours, because somebody could go out and purchase it if they wanted to. Well, I could go on much longer, but I think for now that's enough.
Well, thank you. Judge Wald, well, after Pacifica, the FCC instituted a rulemaking concerning just when indecent broadcasts are permissible, and that resulted in a series of remands from this court and ultimately the N-Bank case. And on the same day that the court heard the N-Bank case in this room, it heard an N-Bank cable indecency case as well that well, had a different ending. Can you take us through those?
I certainly will try, but you'll have to forgive me if I consult my notes, because when I went back to read these cases, they had such infinite complexity, detail, and I counted 15 different opinions if you took the circuit and the ultimate Supreme Court in the cable case into effect. In the Supreme Court alone, the case took 100 pages, one of the cases. So let me see how much I can compact that. Actually, this saga took about 10 years to complete. It started off back in 1988 with the rulemaking that you just talked about, whereby the FCC set a rule of a safe harbor period of 10 o'clock at night to 6 a.m. in the morning for not showing so-called, not showing, hearing so-called indecent communications. Now, at the same time, they said that they would now go beyond the so-called Carlin dirty words application of the definition and perhaps apply it in a broader way than just to those words, apply it in the way in which it was worded. Now, the panel of the D.C. Circuit, which in this case I'm going to name some of the judges because it's interesting the roles they play as this goes through a 10-year period, were Spotswood Robinson and Ruth Ginsburg and David Santel. I believe Ruth Ginsburg wrote this particular opinion. It was remanded back to the commission because the panel said that the FCC had not adequately explained its justification for setting this particular safe harbor, in that it couldn't rely on the Pacifica decision alone. For one thing, in that case, the Supreme Court was acting on a definition that talked about children as being only up to the age of 12, and now the definition of children had been upped to 17 in the new rulemaking, and there hadn't been enough, I won't get into the details, empirical evidence shown as to who was watching which stations at particular times to justify making this safe harbor. Now, here comes an interesting development which carries through the whole 10 years. Congress, we talked about the FCC, but Congress is a major player in this litigation. It's a kind of catch-up relationship between the FCC and the Congress and the courts. It's a real kind of, tripartite dynamic. Because after Act 1, Congress passed a law which told the FCC to ban indecent material all 24 hours. Now, that means no indecent material. That came up for review, obviously, in 1991. This time the panel was Judges Mikva, Judge Thomas, who was then serving on our court, and Judge Edwards. Now, this time the panel unanimously threw it back, saying, look, it's not obscene and you can't have a situation where you have no time, because there are interests of other people in so-called indecent material. There's the interests of adults in seeing it at some particular time. So there has to be some safe harbor to satisfy the First Amendment. Thereupon, Congress passed another law. Congress now mandated the FCC it told them to create a safe harbor from midnight to 6 a.m., which the FCC obligingly did. Except that the FCC added something onto, well, in its rulemaking. It said that certain public stations that had to go off the air before midnight could have indecent material after 10 o'clock, between 10 o'clock and whenever they went off, or between 10 o'clock and midnight, so that there would be some period of time in which this indecent material could be viewed. So, as you can imagine, the challenges came fast and furious. I'll just give you a little sense of the atmosphere. The people challenging the new rule, midnight to 6 a.m., were Action for Children's Television, the ACLU, CBS, NBC, PBS, National Public Radio, on and on and on, which gave rise to what we called Act 3, Action for Children's Television 3. As I recall, Judge Dyke, you argued that case before us, and this time the panel was myself and Judges Mikva and Edwards. Now, we said that Pacifica and the prior president of the circuit in Act 1, the Ginsburg opinion, didn't necessarily cover the case for us because this time it wasn't just agency action, but there was actually a congressional mandate leading it. Now, the FCC argued that the compelling interest, we said that there's a constitutionally protected speech. It could be regulated for a compelling interest. This is the old formula if it was done so in the least restrictive manner. Pacifica didn't cover it because that had ruled only about specific words in a specific context at a specific time of day. The FCC said it had three compelling interests. Judge Dyke has referred to it, but they keep coming up again and again, so I'll set them out. The first is to aid parents in supervising their children. The whole notion of the family as a unit and the parents needed to have some help from the government in supervising the kind of TV that their children were watching. The second justification was what I'll call, and I'm not meaning to be pejorative, a kind of a nanny justification, namely the government has its own, regardless of the parents, has its own pure interest in protecting young children from indecent material. The third was a justification alluded to previously about protecting private homes from an invasion by unsolicited indecent material. As you'll see as I go through it, the first two, we have some interesting back and forth between them. No court ever liked that third invasion of privacy justification. And as you went along, both our court and the Supreme Court, we don't have to get to that. We don't have to get to that. Either one or two of the children's protection ones do it, so they never really did anything with that. But at any rate, the panel, under the persuasive reasoning of Judge Dyke, agreed with the viewpoint that this regulation could not be upheld. We talked about the fact that the governmental interest varied with the age of children, and there was a lot of talk and review of material showing that after 10:30 at night, the percentage of viewers between 2 and 11 dropped to 5%. Now, Judge Edwards had an interesting concurrence, and I'll mention he's perhaps the most assertive in terms of his thinking that perhaps the courts, the FCC, and Congress were all going at it the wrong way, and there were deeper problems that needed to be looked at. He found that the supervision of children justification and the pure protection of children were irreconcilable. And in a later case, in one of his later concurrences, he rejected outright the notion of that the FCC or even Congress had any business doing a pure protection. It was really only the supervision to aid families in supervising their children, which is an interesting allusion to the cultural background which was happening here about everybody worrying about children. And did you worry more about protecting the family so the family could decide what the children should watch on TV, or was there a separate interest that even if the family wasn't doing its job or the family wasn't around at all, then the government needed to be there to protect them? Okay, so we decided no and remanded. The D.C. Circuit and banked that along with the Allied Denver case, which I'll get to in a second. This is the opinion by Judge Buckley, a 5-4 majority upheld the 12-6 safe harbor. It said it met the First Amendment grounds, compelling justification, using the first two FCC justifications of supervision of children and protection of children. It said they were compelling and they were not irreconcilable. As Judge Edwards suggested, they were reconcilable. It didn't go into the home privacy or not. It dismissed pretty readily the notion that the FCC had changed the definition of children, and that put a higher threshold on their justifying it. He talked about a broad national consensus that children under 18 needed to be protected from sexually explicit material. And there was a lot of talk about the empirical evidence about what hours children watched and who was in the watching program. He talked also, Judge Buckley's opinion about Congress ought to be given some deference in line drawing on the kinds of times that were included in the safe harbor, and analogized it to the deference that is given to local communities in setting the spaces around election polling places in which there won't be any proselytizing. But, and here's very, very interesting development. He said, for a majority, that the FCC, however, the 12 to 6 was okay, but the FCC had given no explanation for letting the public stations go off, who were going to go off the air before 12, to be able to put on the indecent material between 10 o'clock and going off. The fact that the only justification the FCC had given was that these stations had to have some time for indecent material, that bore no relation to these compelling interests that protected children. So it was an incomplete kind of regulation. But here's the interesting part. The FCC, the court said, a majority of the court said, must put all stations on the same footing. So therefore, it had to take the other stations, the regular stations, not the public stations, and put them back to the 10 o'clock self-harbor, which of course was the one that had been around much previously, even though a 12 o'clock to 6 a.m. theoretically would have been constitutional. Now, that's interesting because so far as I know, or at least I couldn't find any evidence, everybody was sort of happy about that. They were back in the 10 o'clock to the 6 o'clock safe harbor, which they'd been in before, and I don't think any of this, certainly there was no cert taken, and I don't know if anybody even applied for cert, and that case kind of ended right there. Now, I will say that I and Judge Rogers and Judge Tatel did write a dissent saying that we didn't think the case was analyzed correctly under First Amendment jurisprudence, and I mentioned that I thought that as far as line drawing went, the line drawing in this case was of constitutional dimension, and there was no evidence that the earlier safe harbors, which were 10 to 6, had been ineffective, and no evidence that parents would be assisted. So that case ended there. I'll try to be very quick on the second case, but I will tell you, if Judge Breyer took 100 pages to discuss it in the Supreme Court, it's going to be kind of difficult for me to get it done quickly. The same day that the panel decided the safe harbor case, it had a companion case called Alliance for Community Media versus the FCC. Now, this dealt with cable TV. The initial panel, as I said, was myself, Judges Mikva, and Judge Edwards. Now, again, the FCC regulation in this cable case was following a congressional act of 1992. The act allowed a cable operator on a leased channel, and cable operators were required by federal law to lease certain channels to independent programmers, as well as to allow a franchise, a municipal franchise, when they got that, to set aside one station that the government and the educational, called PEG, public educational governmental channels. Now, what the act did was to say that the cable system operator could permit that the cable system operator could allow the programmer to ban indecent material. And it could also allow the municipal franchise channel to ban indecent material. But it said as to the independent programmer, if they didn't ban the indecent material, then they had to put it in a separate channel. That channel had to be blocked until a subscriber would write in affirmatively asking to be allowed access to that channel. Okay. So we said, the panel said, nix on that whole scheme. They said, we said that state action, and it has to abide by the normal kinds of First Amendment jurisprudence we've been talking about previously that deal with state action. And because this just giving permission to the cable operator to ban the indecent material was tied to the fact if he didn't ban the indecent material, he had to go and set up a system whereby he put it on a separate channel and people had to write in order to get subscribed to that channel, that would be a deterrent to his ever exercising the option of not barring the indecent material once he found it was indecent. So that case, too, interestingly enough, the FCC counsel said in oral argument that it was not state action, and if it were found to be state action, he admitted it would be unconstitutional. Now, when the en-banc court took this one up, it decided that the whole thing was constitutional. It said it was not state action at all, because all that the law did was allow the cable operator to make a decision about whether something was indecent. And it was not sufficient discouragement that if he did decide it was indecent, that he would have to set up a blocked channel access. So it wasn't state action. Now, I dissented in that one and was concurred with by Judge Tatel, partially by Judge Rogers, and Judge Edwards wrote a separate dissent. I'm going to just read a couple of phrases from Judge Edwards' separate dissent, because Judge Edwards was the one who was thinking, and you'll see from what I read, that we weren't dealing with the right issues to begin with. Let me go back one second and say, in my dissent, I referred to the vagueness of the indecency definition, which I pointed out had never been explicitly proved by the Supreme Court. I also talked about the kinds of things which a cable operator, being a sort of private citizen, might well find indecent and bar, like the Mapplethorpe documentary, self-help gynecological examinations, aid documentaries. They would go over, quite possibly, if there were no standards on that, to matters that had artistic or political. Now, Edwards said he didn't think that these regulations, which were mandated in part at least by the statute, would help parents supervise their children. And he thought that was the only valid justification for regulation at all. None of the others were valid. He said that he thought that what the FCC had done pursuant to the congressional mandate was, quote, much ado about nothing much. It didn't begin to get at the real evils of TV or cable. He said cable and TV should not be regulated differently. When Congress chose to regulate indecency on leased and the governmental channels, why they did it was a mystery. There was no evidence that those channels were more of a problem than commercial channels, and this is a theme that goes through, is why are we dealing with indecency when violence is much more of an endemic problem, citing what he later turned into a law review article about a great deal more research being on the harm that is done by watching violent programming to children than is done by the indecency. He said, why are we, quote, spending so much time on something of so little consequence, and that the FCC had been sent by Congress onto a fool's errand? Okay. Just a quick scoreboard right now. The panel said all the parts of this cable regulation of the leased channels had to go down and the governmental channels. But by the time we got to the en-banc, they said differently. The en-banc thought that they were all constitutional because there was no state action. Okay. Up to the Supreme Court, The Supreme Court wrote 100 pages and had something like 6 opinions there. I'm not going to get into them, and I'm just about done. 1 minute more. What I'll call plurality opinion, which was written by Judge Breyer, said, in juxtaposition of what we had said down below, that it was state action. There was no question that it was state action. You had a congressional law, it was state action. But, he said, even though it was state action, just letting the cable operator tell the leased channel, whoever the programmer on the leased channel, that he couldn't air something because it was indecent, that was not a violation of the First Amendment, because he had that right now as far as his commercial channels went, and he'd always had that right, and he didn't think it was, he thought you could sever, Judge Breyer's opinion, you could sever the part about the block channel and just say he had that optional right, he didn't have to. It would have been unconstitutional if they had said that once having found it was indecent, the cable operator had to ban it, but he didn't. On the other hand, the opinion said the part about letting the cable operator do the same thing for the governmental channels was unconstitutional. It was unconstitutional because there really was no compelling justification. Nobody could, there hadn't been any problem with the municipal channels, and nobody could really say that there was any particular need to have it, and they had always had the right to edit their own channels. Now, interestingly enough, there were loads of concurrences and dissents, but I'll only point to one. Judge Ginsburg, who was now Justice Ginsburg in the Supreme Court by the time the cable channel got up to the cable channel got up to the Supreme Court, she joined a very interesting concurring opinion with Justice Kennedy, which said, no, these leased channels and the PEG channels were really like common carriers and public forums, and they ought to be regulated with that particular kind of jurisprudence. Justice Breyer rejected that outright because he said, interestingly enough, he said the dynamic nature of the cable industry was such that at this point it would be wrong to start laying down very categoricals, very stiff kind of rigid jurisprudential standards here. On the other hand, at the opposite end of the extreme, Justice Thomas, who had been on one of those earlier D.C. Circuit regulation cases, said, no, everything was okay. The cable operator had primacy rights over viewers and over programmers, and so anything he wanted to do should have been all right. What do I take from this particular saga? And I'm glad that we still have an audience. Just 4 quick points. That most of this, which took up so many pages, so many trees, and so much time, seemed really to be a dynamic between Congress and the FCC. The FCC didn't have a lot of discretion. The one time they had discretion and they set out that the exemption for the public stations, that allowed the court, or let the court turn it all around, create a different safe harbor. The second was that the dynamic nature of the industry at the time, we were just hearing about lock boxes and V-chips. I think in many cases, this is certainly true in Justice Breyer's opinion, they were reticent to start laying down very strict rules. They wanted to give the industry and the technology time to develop before they did that. We also get the allusions that I referred to where Judge Edwards is saying, we're not even talking about the right thing. We should be talking about violence, not indecency, and we ought to be talking about whether or not cable should be regulated in the same way as radio. I leave it to you to decide how relevant the whole exercise was.
Well, thank you. Judge Dyke?
A brief comment, historical context. Obviously, these 4 Act cases, Act 1, 2, 3, and 4, came up after Pacifica. There was no possibility of convincing the D.C. Circuit to overrule Pacifica. It couldn't do that. So the whole exercise was trying to distinguish Pacifica and to call into question the FCC regulation in post-Pacifica. The first objective was to find an appropriate lead plaintiff, and Action for Children's Television seemed like a good party to be a lead plaintiff because Action for Children's Television was not known for abusing children. Second, there were the various questions as to how to distinguish Pacifica. Well, in the first two Act cases, which involved a total ban, it was relatively simple because you could argue that Pacifica made clear that a total ban was not permissible, and eventually the D.C. Circuit accepted that argument. Act 3, which has been the focus here, was more difficult because the ban was now midnight to 6 a.m. for commercial broadcasters, 10 to 6 for public broadcasters. So the challenge was to come up with a variety of arguments, which you can see recited and rejected in the D.C. Circuit's majority opinion, trying to move on from the Pacifica decision and distinguish the Pacifica decision. So that's how we got there. And then the Act 4, which hasn't been mentioned, was a procedural challenge to the way the FCC administered the scheme.
Well, if I could, I'd like to ask one quick question, but then open it to the audience. I'm going to ask people to come up and speak to the microphones, but I hope that won't dissuade anyone from asking questions. We'd really like some. But let me ask this question, more of a Fox's lawyer made a point of using the F word frequently in the Second Circuit as judges, former judges, commissioners. How would you have reacted to that, and how do you think the Supreme Court will react if that happens in the Supreme Court?
I didn't use it.
Well, the argument for using it is that you sort of buy into the government's position if you treat the word as a nuisance that should be used. That's a pig in the parlor of the courtroom. Does that persuade you in any way, or do you? Well, I think it would have been hard to stand in this courtroom and start doing that. Maybe times have changed.
Well, I'd like to hear from Judge Wald. I don't think that reciting expletives in the oral argument before the D.C. Circuit would have helped us.
No, that's probably right. My own quick reaction was I might have applied to the specific question you asked the FCC's current criterion. Namely, if somebody was dwelling on it and kept bringing it up, every couple of paragraphs, and I wouldn't suspect any self-respecting FCC lawyer would be guilty of this, using it in a titillating way. I think that's the FCC definition. But I would not object if somebody in the beginning said, this is what happened, or these are the two words that were used, because I think it sometimes gets almost ridiculous. I was saying I was watching a TV program today, which was a news program on Prime, on CNN actually it was, and they were showing a political scene where a union person was explaining to his workers about a candidate, and he said, and I don't want you to believe XYZ because that is pure, and then they flipped it off. I think that's just sort of ridiculous. I think the judges are, I think it makes sense sort of to lay it out on the table once what they are. You certainly don't have to repeat it after that.
Some of these words actually can't be abbreviated. We all know what the F word is and the S word. But the FCC takes the position that derivatives of these words are also offensive. So bullshitter, for example, is bad. So I don't know how how do you spell that out in a public or a private? You just have to say the word. And at some point, the whole thing becomes an exercise in utter childishness. I mean, we really ought to force, in fact, I think that the courts ought to force them to use these words. To get out on the table exactly what the words are in some of these cases. But if you look at the omnibus order and the omnibus remand order, which are the subject of the FCC orders in the Fox case, there are a lot of words that are not just the F word. Also, there's a context here. I think, just saying that Bono, when he received the Golden Globe Award, uttered the F word, doesn't tell you anything. You actually have to see it. And by the way, you can see it on YouTube. I urge you to go. It's really quite genuinely spontaneous. It is fleeting, but it's also spontaneous and said in a kind of a way which is so completely unobjectionable in my view. It isn't said for dramatic impact. He sort of, this is brilliant, and it's all over. But, you have to hear it in that. And I think that it would be a real pity if some of this isn't brought out. I don't know who is going to raise these words in the Supreme Court in the Fox case. I suspect they'll pussyfoot around it, But I think that's a shame.
But one of the issues here, as I was suggesting earlier, is what Holmes said, freedom for thought that we hate. And the Supreme Court doesn't have to like this stuff to find it protected under the First Amendment. And it's always struck me that the goal is not to convince people that they should like it or that they should want to hear it, but that they should be tolerant of it. So that's why I am of the view that bringing up the actual words doesn't necessarily advance the objective.
Well, we promised the audience a chance if you'd tell us who you are.
Well, I just wanted to shed some historical light on the next administration that came in. I'm Frank Lloyd. I was the Chief of Staff of the FCC under Charles Ferris, and we walked into the FCC after the election, and we were confronted with this specific case that hadn't been decided under our administration. And suddenly everybody was calling up Charlie Ferris and congratulating him on doing all this great work to stamp out indecency. And Charlie said, well, I don't believe in that decision. I would never have had anything to do with that decision. That was a ridiculous decision. And so he said, let's find the first possible indecency complaint that comes in and make it clear that that case will never reoccur at the FCC. It is infinitesimally chance of an FCC ever coming out with a ruling that something is indecent. And so we went down to the Media Bureau, Broadcast Bureau at the time, and said, send us all your complaints and we'll pick one. And we picked one against WGBH, the Boston Public TV station, for a rendition of Molly Bloom's soliloquy in Ulysses, which had all the 7 dirty words in it. And we said, of course, context is everything. And in Pacifica, it was just that they were doing it for a titillating, abusive, invasive purpose. But if there's any possibility that it's done in an artistic sense, and we didn't narrow it to, classical literature, I think, all of the programs that there have been obscenity findings since would have been swept under our rubric. And we thought that was that. We'd never see it again. And I think for the next 20 years, indecency enforcement was not a big deal at the FCC. It was only since the current chairman came into power that indecency enforcement has been revitalized at the FCC. And so we thought we had whipped that snake, put it to bed, and it rose again.
Frank, I remember Ferris's comment at the time in his speech, you'll know this phrase, that another case like Pacifica was about as likely to occur again as Halley's Comet. Turned out that was a little bit of an exaggeration. Halley's Comet has a periodicity of 78 years, and this one came around, 76 years, excuse me, and this one came around again with shock radio, as you know, about 9 years later. But interestingly, you're right, even when it came around with Howard Stern, the FCC still basically kind of held off as much as it could, I think. until Michael Powell came in. And whatever got under his bonnet, I don't know, but it did. And his successor, of course, the current chairman, has carried on the campaign. So go figure out why.
Michael Powell was a law clerk to Judge Edwards. I guess he didn't read all his concurrences.
Well, let's give Angela a chance. Tell us who you are, Angela.
Thank you. I'm Angela Campbell from Georgetown Law, and my question is going back into the history again, and I wanted to primarily direct it at Professor Robinson. Between the time that the D.C. Circuit reversed the FCC's Pacifica decision and the time that it was argued in the Supreme Court, there was a change of administration. In fact, the Solicitor General's office did not support the FCC's cert petition and, in fact, argued against the FCC in the oral argument. So I'm curious as to why the FCC thought it was so important to take this case up to the Supreme Court, particularly since it was just an adjudication declaratory order in this specific set of facts.
I'm sorry, I wasn't on the FCC when that happened, so I was gone by then, so I can't really speak to it. I just don't know. I mean, I think that I would speculate that the same forces that gave rise to the Pacifica opinion in the first place were still nagging at the FCC. The FCC was under some popular pressure to do something about it, and so they didn't want to simply walk away from it. But that's just speculation on my part.
It sounds right to me. It is hard for people to give up on indecency matters, and I know that a lot of people were surprised when the Supreme Court granted the government's petition in the latest round from what was at least arguably just a garden variety APA case. But
as Erwin Griswold used to say, they probably didn't grant cert to tell the Second Circuit that they did a good job.
It is actually was a little surprising to me that they took cert in Fox without waiting to hear from the Third Circuit decision in the Janet Jackson case, which might have, well, they present basically the same issue, but it might have sort of broadened the record a little bit. I must say that in some sense it's unfortunate that they're taking the indecency issue based on the fleeting expletive question. I mean, I think the fundamental question goes so much deeper than fleeting expletives. That what's really, really troublesome about the court's current enforcement is not simply the fact that it goes after Bono, exclaiming the F word or something like that, or Cher using the F word. It really has to do with the fundamental way in which the FCC is implementing indecency now. The way, for example, that it distinguishes between soldiers in Saving Private Ryan using the F word every 10 seconds on the one hand, and says, well, that's all part of the artistic integrity of the program, so that's okay. But on the other hand, when the same thing is said by some cops in the gritty NYPD blue, oh, well, cops don't swear. What alternative reality are we living in here? So it's that kind of thing, and that has nothing to do really with fleeting expletives. It has to do with a fundamental vagueness. It's that issue that really caused me to change my mind about the wisdom of the whole thing. It just can't be contained.
Was there any consideration when you were at the commission to commission saying this isn't our business, it's a criminal statute, and we ought to allow it to be enforced as part of the criminal process?
That wasn't really raised because a separate section in the Communications Act permits the FCC to enforce 1464. The FCC has always taken the disingenuous view that so-called forfeiture penalties are not criminal sanctions, so they get around your issue with the jury trial. But no, they clearly have jurisdiction in the statutory sense, and so they've never thought that they should duck this by saying that well, is a criminal sanction. I mean, I think that would be a good ploy to use, but probably too late in the day to take that view. They get all riled up because of all these complaints, but of course some of these public complaints are generated by their own decisions. So the more indecency decisions they hand down, the more they generate filings from Morality and Media and Parents Television Council and others who have their own agenda here. And that sort of builds up a cycle of political and public pressure. So I don't think there's anybody actually who wants to turn it. Congress has never said, oh, we want to turn this back to the Justice Department or something like that. Justice Department, as you pointed out, doesn't enforce these statutes.
Well, thank you. Thank you, Judge Wald. Thank you, Judge Dyke. Thank you, Professor Robinson. I really appreciate this today. I'm sorry. We have one more question.
I'd like to ask you and the others whether you see it possible that the court would go more broadly and reconsider Red Lion, and what would it take, if not this case, to squarely reconsider the proposition for the Red Lions?
Well, a brief response to that. I think it's probably more likely that the Supreme Court would reconsider Red Lion than it is that the Supreme Court would reconsider Pacifica, but that's just a guess. I think that in today's climate, that having FCC regulation of political broadcasts outside of candidate broadcasts probably would be viewed as raising a greater issue in the Supreme Court than FCC regulation of indecency.
The brief that I was the principal author of, and the amicus brief that Chris mentioned briefly, argues that in fact the court should not stop at the fleeting expletives issue before the Fox case, but should in fact revisit Pacifica and overrule it. And we argued that, I think, because once you get into the way in which the fleeting expletives policy, the indecency is now being implemented by the FCC, it's a house of cards. The whole thing just collapses. So there's really nothing left. And our argument in the amicus brief is that basically enough has happened that has changed the premises of Pacific itself. And Red Line is just a distraction. Whether the Supreme Court, if the Supreme Court were to overrule Red Line, that would be a case for dancing in the streets. But I don't think they're going to reach out to Red Line scarcity in this context. What we tried to argue was that what has happened since Pacifica is this whole idea of a special character of broadcasting as a pervasive, invasive medium has just dropped out. It's no more invasive whether the TV signal comes in by wire on cable or comes in over the air. And yet the Supreme Court has specifically said that you can't apply indecency to cable. The same is true of indecency on the Internet, and we argued that basically it's quite clear the Supreme Court has now held that you cannot have an indecency policy applied to Internet communications, but the same kind of invasiveness is present there. We also pointed out that the whole character of the media has changed, media industry has changed. When Pacifica was decided, cable was still, well, it wasn't in its infancy, but it was in its adolescence. Now, 86% of the American public get their television via cable. So the 86% of the television that is shown to the public is not subject to the indecency regulations, at least insofar as it's on cable and not on broadcasting. And there's got to be something wrong with that. I mean, there's got to be something that's fundamentally foolish and incoherent about that. I, like Tim, I don't think there's a real chance that, well, there is a chance, a little chance. We had to put this argument on the table because I think it has to be put out to the court at some point. But I don't think there's much likelihood that the Supreme Court will take and revisit Pacifica It will be good if they even consider the pleading expletive issue on constitutional grounds. There is a non-constitutional issue before the court, and that is that the FCC's policy violated the standards of the APA, Administrative Procedure Act, and the government has urged the court to simply address that issue. I hope they don't.
Judge Wall?
Can I just add one small note of kind of, not realism, but I had to ask myself after I read this long saga, which I bored you with, well, what became of it all? Did it all result in much difference out there? And the fleeting expletive case raises a little bit the same question. I just want to read you one paragraph from a Washington Post TV column a couple of weeks ago, which says, "Your child is 3 times as likely to see characters on broadcast TV having primetime sex with pets, corpses, or 2 other people simultaneously than a happily married couple having a roll in the hay, according to a new study by one of the self-appointed TV watchdog groups." They pointed out the TV has a recent obsession with outre sexual expression, including threesomes, partner swapping, pedophilia, necrophilia, bestiality, not to mention strippers, pornography, sex toys, and something called kinky or fetishistic behaviors. And again, we're not talking MTV here, folks, just broadcast TV. I don't suggest, this is not coming at you saying we ought to have more indecency regulation. I guess it's coming at, it's a very, like violence, it's a very sticky wicket as to whether or not the government has much of a role to play at all here. And they don't know how to define yet, I think, indecency in a way that satisfies most people, just as they fuss all the time about all the violence on TV, but they don't really know how to define what's okay violence on TV and what's not okay violence on TV.
Well, with that, let's thank our excellent panelists. Thank you very
much. In behalf of the Historical Society and the Federal Communications Bar Association, I want to thank the panelists and Chris for a wonderful view of indecency in the world today through broadcasts. I also want to answer what might be a question that you might have as to where our 4th panelist was. Judge Silberman advised us last week that he would not be able to participate and said his regrets. We share his regrets, but we've had an outstanding panel. Thank you very much.